I watched the pretrial hearing in the Alex Murdaugh case.
Okay, this is him suing Becky Hill.
No,
This is his new trial.
This is his new trial for murder.
Yeah, okay.
Death penalty is on the table.
That's crazy.
I don't think that that's right, but it is what it is. Maybe they'll take it off.
I think these courts, these prosecutors, they overshoot the moon all the time. I think it's going to bite them. I don't think anyone's going to try to convict this guy of death.
Well, I think it was a death penalty case the first time, but they took it off the table the first time. So,
right, that's what I'm saying. And they probably, I think if they go for the death penalty, they're gonna, the jury's not going to go with it. I don't think a jury would convict him to death. He's not like, if he did what they say he did, he is a horrible person, but he's not like a career criminal that has never, he is kind of a career criminal. He's not a violent career criminal though. Financial.
All right, criminal. I'm gonna share this.
Okay.
Sorry, skipping ahead to where they actually talk.
A lot of waiting around in Colleton County Court.
Jeez.
I don't know anything about.
All right, here we go.
A lot of not doing nothing. Oh, there he is.
All right, judge is coming in.
Please be seated. I see we have a full house. Good morning.
Oh, Lord.
For those of you who've never been to Lexington County, welcome.
I know, like everybody sounds like your mom.
It's especially funny to me when I hear it because it is a very distinct version of the Southern accent too.
Right. It's like near where you're from originally. So
yeah, and I can hear it like it's like a sensory memory when I hear it.
Yeah, everybody sounds like Janet.
Welcome to the Lexington County Courthouse.
She looks tired.
I'd be tired too from dealing with this bullshit.
She's like, ugh.
All right, we're here for a status conference.
Are you?
I'm going to get the clerk to call the case, please.
In the matter of State of South Carolina versus Richard Alexander Murdaugh, indictment number 2022 GS 15.
Better get a better clerk this time.
0592 through 595.
I think Becky Hill's working in Massachusetts.
Oh no.
Hi, Mr. Waters, how are you?
That makes sense.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka.
I know.
I have Don Metters as well.
I know Mr. Matters.
And then, you may see at various times we have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
Right. Welcome. Let me, Mr. Hartlewy, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
We support Your Honor. Jim Griffin.
Mr. Griffin.
Bill Barber.
Mr. Barber, good to have you. Okay. All right. I've made some notes on a status conference, and I'll let y'all talk in just a little bit. But I want to go over what I want to go over.
I love how the prosecutor stood up to say something, and she's just like, I want to go over what I want to go over first.
She's like, sit down.
You all have a chance to talk after.
This is my court.
Yeah. Because I want to make sure that all the discovery in this case is complete. And I may.
She's not playing around after that last case.
No. Good.
let me tell y'all, I don't know anything about the first trial. So when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, him formally being an attorney and that sort of thing. So it's my understanding complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review some of the extractions as it relates to this phone and that sort of thing. As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive production.
Let me speed this up, do you mind?
Not only
Yeah,
from
go ahead.
the murder investigations, but also from the very extensive state investigations as well. So we have provided those.
Hit it with the 1.5
Honestly,
time.
I'm not aware of anything in the categories that you mentioned that are not provided.
And not anything that needs to be reanalyzed or anything that the court would be waiting on.
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to those defense motions that filed late last week. Came out Sunday to write those.
Let's get this trial going, guys.
Testing on DNA. We put it on motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're supposed to do, happy to facilitate those.
I love how I put it at 1.5 speed, and they're all speaking at normal speed now.
He's speaking pretty
And
fast.
then with your honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
I want to address everything but the DNA.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example. Let me hand this up to Your Honor and hand copies to.
He's introducing evidence now. He's like, I'm not ready. I'm ready.
Your Honor, this is a transcript of the interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, processed the scene, and were very involved in forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to the question, I believe he had some help in the aftermath. Or Rutland, yes. Captain Chapman, you know the disposal of weapons, moving around a vehicle. We heard so much about SLED and AG's office, they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, staged crime scene, clean crime scene. We expect to find more evidence or less. And that's what's kind of hard to get people to understand is we didn't find a lot. Why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene. That he had assistance under their theory, or there were other people there. We need to have that furnished to us. And we have other witnesses that testified at trial saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene along with Rutland, who processed it that night. We need, and when the process of doing this, to determine if they took those statements or the report. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate. We don't have subpoenas, we don't have a grand jury, we don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? Have they investigated And I must tell you, there are a lot of pieces of information out there that maybe they just stopped once they got the conviction, didn't do anything else, that is inconsistent with our desire to get a conviction, or have a conviction held.
I wonder if they're going to try to show that SLED is corrupt.
Maybe.
So they didn't follow it up. Maybe it does need to be followed up. But we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material developed since the trial. And of course, all of us were shocked by the court's conduct in the trial.
I wouldn't be surprised if SLED is corrupt.
But it's hard for us to go back and look at, and we haven't done a thorough check of it, all the testimony, and read it all, not in the sense of appeal, which we've done, but in the sense of, in criminal cases, we don't have depositions. We don't have them here. We have a transcript. Not every. I'm sure they're going to get rid of some of these witnesses. They're horrible.
So none of his financial crimes, I think, can come into this.
Yeah, you were telling me that before.
And it came into the first trial.
Yeah. Additional witnesses. But most of the witnesses, we have their transcript.
It gives him a better shot.
We need to go back and read all of that.
Yeah. I think he has a better shot if they go for the death penalty, too.
So
he doesn't have much of a shot, though.
I can't say we don't have it all.
Everybody in the nation thinks this guy's guilty.
I think
one of the other things we talked about,
if the defense can frame it as
Murdaugh's access to that information,
the state of South Carolina is corrupt and unduly trying
I'll get to
to,
your motions in just a little bit. What I really want to know is about
prosecute him,
text messages,
then
cell phones,
he might
video
get away.
recordings, toxicology, fingerprints. You have all that discovery.
we're not sure. But we need to review it as if we're getting ready. It's brand new. Okay. We looked at it 5 years ago, 4 years ago. It doesn't mean we know we have it. We'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that. Yeah. Right. One of the points remind me.
It sounds like the defense is trying to delay this for some period of time.
Vehicle until halfway through the trial. That is not the attorney general. That is not furnishing it.
Well, I mean, they need time to prepare defense, so whatever.
We had to do that on the run. We want to go back and analyze that. Have an expert analyze that even more.
They need to give him as much time as they need to prepare for this because, he needs a fair trial this time.
Yeah, absolutely.
No mistakes.
Yeah.
I do want to emphasize, the attorney general about it at the same time we got no inference, anything improper.
Okay.
So part of what we need to do, we need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge. I can't tell you today we have everything we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually SLED had sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got it. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us limited coverage, which is all provided to the defense. I think when that testimony came out for the trial, somebody at GM was watching. They were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to a usual form. They assisted and agreed to go forward because each hour curious about what that done. So that was nothing was called a mistake, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. After him saying, we don't know what we don't know, well, I know my applications are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, we're always constantly auditing that and doing our applications, but I take discovery applications very, very seriously. As far as these musings, I have to watch this. Musings of some captain about whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennel. That hose was not put back the way that it normally was coiled by the person who's in charge of taking care of the kennel. So he may have been talking about that, but ultimately, while Collison responded initially, the scene actually was in charge of the process by SLED, and they had access to all that information. So to sit here and imply we don't know what we don't know. Well, I recognize that, but I know that my obligation is to provide that information to the defense. And if I'm aware of it, it's been provided. And we have done that. They had it well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts and was immediately disclosed to them. They had every opportunity to process that information, and they agreed, let's continue on. So that's not anything, any sort of indication of a bad process.
So the bottom line is they have everything that you have.
My knowledge, yes, ma'am, and we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time.
Well, again, we have that DNA.
The DNA, and I'm going to get to DNA in just a moment.
Of course, it was analyzed ahead of time. I wasn't
Right.
as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions. And if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, if we put it in our motion, ultimately there's absolutely no evidence that Maggie Murdaugh was in trouble with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common how sensitive such DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do if reasonable. We're the first to do that. And if there's any to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first trial that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No other question. But it raises questions with us, not whether
So the SLED investigator is. Did you hear that?
Yeah, they're accusing him of withholding evidence from the first trial.
Right, and he's been dismissed for withholding evidence in another case.
Yeah. I'm gonna be honest with you. The first trial, I was fully like, Murdaugh is guilty. I don't care. I don't like that guy. Get rid of him. Right. This trial, I do feel kind of sorry for Murdaugh. I am kind of on that whole anti-establishment side of this now, where it's like, well, the state had their chance. They tried to play they did, well, maybe a rogue actor, but whatever. Somebody tried to play their hand too hard. He got convicted for what's unfortunately a bogus trial now. In this trial, they better bring their A game. Like, I actually feel more sympathy for him as a person who is obviously being targeted by the administration based on him being high profile, less on the actual facts and evidence of the case, but more on it being him a high profile person who had a lot of money that, people don't like.
held by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the Tuckman case after the trial? We had evidence. And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, look, we want to try to stay as quickly as possible. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week to expand on that a little bit. We didn't feel that we wanted such a motion.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pretrial conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll probably have several. And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpootlian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes. And we kind of touched on it a little bit. Experts. Do you know how long? And the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one. So I'm asking Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people? And
Okay. She's like, this is an old case. It's not. Because it happened a while ago, sure, but this just came up. He was just granted a new trial.
Yeah.
So I don't necessarily agree with her. She should look at it as brand new.
Get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be SLED. So I think that we are ready, within reason, of course, to do this as expeditiously as possible. We do have another expert that testified from the FBI, things like that, but much of that is the same. And so as far as the state's position as to scheduling, I know we want to say this publicly. That we were trying to do this before the end of the year, by the end of the year, for whatever it's known. So I'm not aware on the state side of the expert issues that for additional delay.
All right, Mr. Harpootlian, how about for the defense?
We have 8 expert witnesses. All of them are new. All of them are just beginning get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. Critical will address the specifics of that in just a moment. But to try this case this year, you guys talking about going to the death penalty 4 months ago or 3 months ago. To try it before the end of the year cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take a bank box at a time to read documents, almost 20,000 pages of documents. So we came up with a way.
Well, surely, Mr. Harpillion, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the material was on. It's ridiculous to require him, not all due respect, to require him to have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, contrary to Mr. Waters' motion, is ironclad, no chance of it being distributed. We'll give him a laptop. It's encrypted. Since there's no attorney-client on it, corrections can look at it, SLED can look at it, anybody can look at it, and let him look at that without us having to take hard copies of stuff down there and review it with him. Can't leave it with him under the court order because the procedures can't take the discovery and leave it because the court order is prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, he could be reviewing these documents and experts as we're reviewing them. I mean, let's not forget, he's a lawyer. I mean, he's just a hard lawyer, but he has probably more trial experience than many of the folks on either side of this. So he understands what he's looking at much better than any client I've ever had. So I think it's important if you're going to try to expedite this for him to have, and we can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks obtained, have them look at the adequate material, look at the state's testimony that goes down around. And of course,
6 months seems really reasonable to me.
Yeah, he's saying they won't be able to start the trial till next year. But I mean, he's right.
Right, because they
years.
need 6 months.
Yeah, it's been 5 years since
they have a change in who they're using, taking a different approach. We need to know that as soon as possible. I would point out that they were giving us discovery in their last case after the first week of trial, in the second week of trial. So we can't have that happen again. They say they got it all. We're going to assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. What we're comfortable with is late spring, early summer next year.
Okay.
Look at that. Given, I mean, if we have to go down there, one of us has to go down there 5 days a week. And you know, incarcerated on now, so it's 2.5 hours. It's a half an hour to get in. So before we ever see it, it's 3 hours. And then you only have 3 hours with them, and then it's 3 hours per time. That's why the laptop is so important.
Okay. Ms. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, you know, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are.
I'll get to the DNA in just a minute. And then we'll go forward on that.
You don't want to talk about DNA yet.
I love how measured and in control she is of this.
Yeah.
And they're respecting that. She laid down the law as soon as they all walked in, and
well, she wants a trial now, it sounds like.
Yeah.
All right. Let me talk about this computer at the Department of Corrections. I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpillion? I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case. It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpillion?
Well, Your Honor, the issue of that is what is the state grand jury material? I do think if we can designate what that is. It's beyond grand jury testimony, which is there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, underlying records and whatnot. And so, is that really sensitive grand jury material? And someone's introducing evidence at the trial. I'm sure of that. But so no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of subpoenaed documents and information have been produced.
And Your Honor, the issue is dissemination. I mean, he has the right to read.
Oh, absolutely. I said that. It does not prohibit him from reading it.
The issue is dissemination. I mean, we're just basically talking about a big Kindle. You can read on it. You can't send emails. It's not connected digitally or cell or Wi-Fi to anybody. It can be. I'm going to say this: the Department of Corrections is extraordinarily professional in dealing with us, giving us access to them. But no complaints with them whatsoever. What we'd like is we'd like that laptop with the warden and corrections have total access to it. It can be inspected by SLED to make sure it can't transmit the image, a message, and be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. These are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's very difficult plan. What we want him to look at, and we can certainly do that separately with hard copies. So you have to go out there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing to be about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to murder. So it's much bigger than they say. I don't have numbers from Your Honor, but it's at least 20 witnesses, multiple subpoenas, and so all this has been done. And it's, as well as Judge Newman issued a second, my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. So all this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying to best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to, is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet and was taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member who was and so this is not a guy who was, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be.
Did you catch that?
No.
So they just said that they don't want him to have a laptop because this is an individual that was seen. He had his tablet taken away for misuse. This is an individual that was punished for receiving contraband. So they don't want him to have a laptop in the jail with all of his case files and everything.
Yeah, it's a dumb argument though, because like the guy said, they're looking for him to have like a read-only Kindle type thing so he can read the documents. That's like air gapped and doesn't have connection to the internet. It's like, what's he going to do with it?
I mean, you give these guys in prison a tablet, they're going to try to look at porn.
Yeah, but if it's air gapped, you can't do that. It has no internet.
Right.
Lockdown and I understand the issue very well. The state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from their
look.
with the use of devices.
He's over this guy's bullshit. Alan Murdaugh is like, fuck him.
He knows too.
The fact remains is he's an inmate. And SCDC adamantly opposed to there being some laptop being access. So for this idea that SLED is going to be able to review, attorney communications and work products on that, I don't understand how that's going to happen. Now, SCDC is happy to accommodate the defense. And so any meetings they have, no one says that the defense can't bring down digital evidence to review with them under their supervision and then take it with them when they leave. That is absolutely the way it should be. That ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections put in place, have a laptop. Because frankly, the reality is inmates are constantly and successfully violating whatever protection for this. Despite everyone's best efforts, you're doing a great job.
Okay. Sure.
I had a series of emails, and I don't see the Department of Corrections here today objecting. I had an email chain with Ward and he doesn't raise those objections. He just, and we bring another laptop for internet cellular for Wi-Fi capabilities. So, and that's what this says. So, with all due respect to the Department of Corrections, if you don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barlow, or Ms. Fox have to go down there, 3 hours down, sit with him for 3 hours, 3 hours back, we're talking about at least the end of next year, not the beginning of the following year, to get this report. I can't be working on experts. We can't be interviewing witnesses while we're tied to sitting there and babysitting him while he.
He makes a really good point.
Yeah.
Because if you think about it, Alec Murdaugh was a civil litigator and has probably litigated more cases in a courtroom than any of these guys.
Yeah. Yeah.
Right.
Well,
he was a civil litigator for, for like accidents. What kind of lawyer was he?
I thought he was a financial lawyer.
Look it up.
a laptop that doesn't have any capability to communicate or copy. And we'll be happy to have SWED inspect it. We'll be happy to have Department of Corrections inspect it. But, the idea, we bring laptops in. We give it, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it?
He was a personal
some
injury
office-
lawyer.
Yeah, that's what I thought, like ambulance chaser
Wrongful
type
death.
stuff.
Yeah, personal
Right, so
injury,
he-
wrongful death.
Right. So he was in civil court. Imagine how many court cases he's litigated.
Yeah, right. Well, and
A lot.
I think the ask is reasonable, right? Like they want to be able to have him review all these documents so that they can move quicker.
Right. And he's
Who-
saying it'll have no internet capabilities and it will be in the custody of the warden.
And all the prosecution's basically saying is this information is too sensitive to give to somebody without like supervision. And it's dumb. I don't agree with that.
At the institution, keep it and give it to him when he needs it. And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Warren's job to legally prejudice the defendant, but this is beyond the pale. This is beyond the pale. I'd ask you
I agree.
to remind Mr. Warren that he has an ethical duty to do justice is done, not to get a conviction. Thank you.
Mr. Harper, when there's better than that.
I don't.
And that,
Okay, we're not going to go there. But
and I have no intent to prejudice. Prejudice suggests a decision on your part later.
and the court doesn't take it that way, Mr. Waters. All right, let me tell both of you. I took
Mr.
the liberty of
Waters.
calling the warden
He's
and
mad.
talking to him about
He's a dick.
the laptop situation.
I think he's
And-
doing what the guy said he's doing. He's
Because I too
trying
used to
to.
practice law. I remember
this
terabytes of
difficult.
discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I
Not
Hold
letting him have access.
because I too used to practice law. I remember terabytes of discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
It's very simple. It's
Half of a terabyte. Okay. I talked to the warden. He will not allow a laptop. And for safety reasons, he said he would, quote, make available a conference room.
She's doing homework.
Yeah, good for her.
Counsel may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. No other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpelian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of.
Okay, don't let him have it in his cell, but provide somewhere else that he can do this.
Well, they were saying that he could do it with them in a conference room somewhere.
Fine. Why can't he do it in a library?
I don't know. I think the defense's
Out of my
argument
control.
is that they want him to have it in a cell so he can be constantly like reviewing it.
Right, but I'm saying there's no compromise here. It's like sell or nothing. Like, how about somewhere else?
That's how they do it.
I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay.
We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room with us, look at it there. Does that make a difference?
Well, I'll ask him. But when I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally. Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before.
Move him to a different jail. He needs to be able to defend himself.
Yeah, I don't disagree with that. I think they're
If he
both
says no,
they're both
ahead.
pushing for the extreme of what they want to hopefully end up in the middle somewhere.
and it's for security reasons, and the answer is no. I'm not going to allow it. You understand? Mr. Harpelian?
But
Mr. Waters?
law clerk or other person, paralegal?
He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not going to limit you to 3 hours. They can say 8 hours if they want. He will make a conference room available.
I bet he'll hire a paralegal that's local to Columbia,
Yeah.
because Poot, I think, lives in Budford or whatever it's called. Where's Alec Murdaugh from? Beaumont?
No, Buford.
That's what it's called. I call it Budford. Sorry. Yeah, he's from Beaumont. So that's 3 hours to Columbia.
Yeah, it's a ways. It's not close.
Yeah, but I bet they can hire a paralegal local.
Yeah, there's someone in
So he
Columbia.
could see the
This will be their
material.
only job.
It does not have to be a lawyer. Okay, that
Your Honor, I spoke with the director of General Counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
right. You know, I want him to have all this discovery. He's entitled to all of it. You know, it's safety concerns. It's
Your Honor, 100%.
if you can have a law clerk or a paralegal go down, then you're satisfied. Mr. Harpelian, that'll help you out.
Automatically, if not limited to 3 hours, it makes that 2.5 hour trip down, 2.5 hour back worthwhile.
Okay. Well, then
Yeah,
I
it
will,
says 2.5
verify
hours
that
there and back.
Send y'all an email tomorrow on that. That's okay. All right, perfect.
Thank you, Your Honor.
All right. Now, let me go through. I had a motion filed for the defense, and I just want to put this on the record.
Well, just think about like when we would drive from Charleston to Savannah. You know,
Yeah.
Beaumont would be about 45 minutes to an hour south of Charleston.
Yeah.
And then if we're driving up north, you have to go west first. Or you're going to see your sister, that's in Columbia from Charleston, that's an hour. So yeah, it's going to be like almost 2 hours.
Yeah, it's more like an hour and a half for Charleston to Columbia, and then like 2.5 hours from Buford to Columbia.
The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpelian.
Why are they insisting on him being shackled though? I mean, he's obviously not, I don't think that he's a danger. He's going to try to kill anyone.
Perception.
Right.
If he's
And
shackled to the jury, and the jury is supposed to be kind of agnostic to the trial, they assume they're more
No,
likely
they-
to assume he's a dangerous
they
person.
need to put one of those things, those belts on him underneath his clothes. Let him wear a suit. Let him look like a civilian.
Where he
I agree.
withdrew that motion. That still stands, Mr. Harpelian?
Yes, Your Honor, although we may renew the motion, the reason for this is potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make it more difficult for us to get a jury. Now, again, Mr. Clark's argument is specious. He's not dangerous. He's only convicted of stealing money. Now, Judge Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is this is our ability to get a jury. So I would ask that he be allowed to come in the courtroom unshackled in, I would call it street clothes. Now,
So are you renewing your motion now? Just want to make sure.
I want you to see today. Is this. I mean, chained around the waist, chained to the hands, chained on the feet. I mean, this guy is not a serial killer. He's not, Ted Bundy.
I agree with that.
How was he accused of stealing Frankenstein? But he was accused of stealing Frankenstein. And Judge Newman allowed him to come unshackled in his street clothes every hearing he had.
All right, I did read your response, but I'll be happy to hear anything, and I'll take it under advisement.
Well, again, they withdraw the motion, and now they.
Now they,
This goes back to, it's not the state's fault, he's an inmate serving a 27-year sentence, okay? This is, again, SCDC's policy for a non-jury court, for him to be trusted out in restraints. He not only faces 27 years, but an additional 4 years in federal court, and he's also indicted for a federal murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to keep someone restrained in the civilian court. So I'm here to represent what is basic policy and procedure for inmates serving long colonial sentences with SCDC. I completely understand that we have a jury, the calculations are different, and that is going to be a different thing to do. The remedy for all of that ultimately is our process. It's going to be jury selection. It's going to be instructions from the court, which the jurors are going to follow. I know our systems can.
okay, thank you. All right, I'll take it under advisement. I'll issue an order on that. Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pretrial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now that I've been interfacing with. And they will be better able to answer specifically how long it will take. We've agreed to pay for it. And just background information.
I'm going to let you pay for it.
These murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year, on 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample. They ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test to Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who had done a DNA test, ancestry test, of the person who committed these murders, Brian Kohlberg. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say that.
Look at this lady. Why does she look like she's shocked? Look, that facial expression doesn't go away.
Have enough samples to get through.
Is she like one of those dolls that, you know, those?
She's an android, maybe.
I mean,
she looks like one.
CODIS, and I've talked to the lab.
She doesn't blink. She's making jerky movements. She's a robot.
And that's not an issue. CODIS uses analysis.
She was just rebooting.
It's called STR. This analysis is SNP, and they call it SNP.
She does look very concerned, like a scared cat.
SNPs has 500,000 data points that they analyze. Now, it takes a while to do that. And so, you know, we're going to have to see what the lab says. They've asked me to get information from SLED as to, you know, they like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd asked Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they are they're certified. They work with law enforcement. I don't know that they work specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send.
Correct. And they can work with an extract that SLED used when they did their SDR analysis. They can work with that out there. They told me. But
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures. And then once they privy that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back to the trial. That's precisely what I put in my motion. Let's talk to let the experts talk so that my experts can hear, you know, what it is that they propose that they're going to have to say.
And I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alec Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential, and that potential. The ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, you know, innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial. Anything, Mr. Waters, you're going to give them the name of the person that SLED that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
Right.
they work with a lot less than
Okay.
SLED.
Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward. And we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away. All right. Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions, and then I will decide for you if we go that route.
Even in spite of the acrimony here today, this is what we're able to talk to each other, and we've already talked about this. And I think we'll have continuing discussions.
An answer for me?
Try, I don't have to drive you down.
Yes, Your Honor. Of course, without taking a specific position right now, I
Right.
this morning that we can take some things around, and like you just said, if you agree, great. If you don't, then we'll work.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address, I see Mr. McCullough sitting out there, and then I also have another, they're both the same protective order, but they're wanting two different things.
Ours is not the same.
That's right, they're two different things. Right. As far as, but I think before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Yeah, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities and actions.
Right, because I did, yeah, and I did receive something from SLED, an email from SLED.
Council Advocate is present here today, and Sledge.
Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings, and from the state's perspective, we're happy to come wherever Your Honor happens to be.
Okay,
And we're more than happy to come wherever you are, although this production of these hearings might dictate, certainly suggest we come to a venue like Washington County with a 20-room extraordinary.
I think they've done a really good job with security and with the press and being organized. And this is my own county. Let me just ask and throw this out there. Mr. Waters, is there any objection if we hold pretrial here? The reason being, we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties, and I don't think it would be good to hold a pretrial there. Does it suit?
I mean, from the state's perspective, again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Solicitors, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenient for parties.
It's not far for anybody to travel, Mr. Harpootlian? Okay, and I will try to make sure that when we arrange these pretrials that we will try to be here in Lexington. Anything else, Mr. Waters? Defense?
That's all we have, but if we could talk about that schedule for the next pretrial.
Oh, I'm getting ready for it right now. Let me tell you what I have. I've gone through my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
Right, so chronological order, the first would be
July 29th.
I'm scheduled to be out of state from the 29th to the 30th.
Okay, then let me move on to August 13th and 14th.
We have a mediation on the 13th. The 14th is available. Yes, sir.
14th was the day.
August the 14th, it is. That will be our next pre-trial. Now, with that,
Keep an eye on these law enforcement officers. They just keep glaring at the guy. I just noticed this. There's one sitting down, one standing up.
said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have your motions, I understand that some of them are late. You might think of something at the last minute. That's fine. But please don't file something at 10 o'clock at night and expect me to rule on it in the morning. Okay?
I apologize for those coming in late.
No, you're fine.
Just to make sure we had something else.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different. But please don't do that to me, okay? Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that. But I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter. It is the March, is it the 28th? I think it's just a week. It's March 28th. So I'm thinking April 5th. I know that we'll have a new attorney general coming in.
April 5th, that gives them a decent amount of time, but they look worried.
Yeah, I don't
Mr.
know.
Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well. When I set a trial date, I don't do continuances. I don't do it. That'll be a really good reason. So how does April the 5th sound, Mr. Waters? Mr. Harpootlian?
Will be made with some contingencies if the DNA takes longer, for instance, or
I will have that information by next pre-trial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
more than happy with that. Murdaugh, more than happy with that. I just, again, everything is like, because science in all these areas is much better than it was 5 years ago.
I understand. Technology changes overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court, but the Supreme Court also addressed financial crimes evidence, and depending on how much of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue, and it is going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial, and so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up. And so I'm just asking maybe some earlier date where we can have, Your Honor, address those issues.
We will. I'm just going to tell you, I like to address all pretrial matters beforehand, because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
She's not playing around.
Well, we thought
No, I like
the
her.
trial to the prior trial being hard cards on the table is exactly why we thought that was in this one.
Thank you. I appreciate it. Anything further before we adjourn, Mr. Waters and Mr. Harpootlian? All right, perfect. Have a good evening.
Okay.
Mr.
so
Harpootlian.
you like Dickie Poot?
I like his name. I feel more sympathy for Murdaugh this time around than I did last time. I think he's got a chance based on just if they go for the death penalty and the jury is at all sympathetic to him, I think they might let him go off death penalty. But they're going to charge him with like 16 different things, right? So they get at least one of them.
I have no idea how this is going to go. I mean, you would know better than me what juries are like down there, but everybody thinks this guy's guilty.
Yeah, but now everybody thinks this guy's getting a raw deal from the government, and it looks bad because they don't need to. So it just looks like they're abusing him.